The rules of the Supreme Court in respect to the presidential election disputes, I think, are set out certain processes that make it easier, some sort of toolbook to allow the judges and that court to deal with the extremely tight timelines. For instance, after the filing of the petition, service ought to be on the same day in soft, online. Physical service of the petition and the respondents has to be within 24 hours. The response must be then within 4 days. The timelines are tight, and somewhat is an attempt to balance giving sufficient opportunity to the parties to make their cases, yet giving some space for the court to hear and determine the matter in a way that they can sufficiently interrogate the dispute. Then there would be, and what I thought was an ingenious manner of dealing with interlocutory applications. The filing of interlocutory applications and the end of the process where alongside the final responses, they be dealt with at case management level, the decisions be granted if it is peremptory, reasons can be granted late, can be given alongside the main decision. The other manner I think that has enabled the court to carry out its mandate within the tight timelines is to give a decision and then the reasons later. I have known that in certain jurisdictions the reasons can come 6 months, 7 months, 8 months later, but the decision, the time the Supreme Court has set on itself and the rules that the decisions must be, I think, within 30 days. So there is no anxiety on the parties to know the reasons, yet it gives sufficient time for the judges to explain themselves fully on what is often very contested and extreme public interest issue matter. So I can see that the rules over time, that the rules that have been put in place can assist the court in dealing with those time frames.
Thank you very much. So you see, it's very tight, the time frames.
Yes.
And therefore, you can imagine when we are listening to a presidential election petition, we are hardly sleeping, and we are working throughout. Do you think that you have the, not only the courage, but the character to manage to work under such intense pressure, lack of sleep, working with documents coming in, doing rulings overnight? Do you think that you, in your experience, this job that you have applied for, in those circumstances, that you have the character to manage under such high pressure?
Thank you. In applying for this position, I am acutely aware that the question of presidential elections is a cyclical affair. It invariably happens every 5 years, and I've watched the workload that the judges must deal with, and I'm obviously sympathetic. Nevertheless, I think in my the courts, the other courts which have been called upon to deal with election petitions are also under certain strict timelines. The resolving quickly interlocutory matters. In my experience at both at the High Court and the Court of Appeal, I've had to deal with those matters. I have not had any difficulty at all. I think I have the endurance and to carry out the job, notwithstanding the difficulties that the timelines portend. In doing so, I have thought of efficient ways in dealing with timelines, is to be overly prepared, make use of research assistance where it is available, to prepare myself even mentally of the task that will be ahead of me. I believe that I would have no difficulty at all.
Thank you. You have been in a collegial court. You are in a collegial court. How do you manage when you're dealing with difficult matters, when you need to discuss? You had a dissent in the BBI, so obviously you're not able to persuade your colleagues on one or two issues. But what are the necessary elements of collegiality when discussing hard cases?
When you sit in collegial court or a multi-member bench, you realize that members of the bench, the very divergent opinions people would have on or take in matters. Sometimes when it's a difficult matter, there would be areas where there is deep disagreement on legal positions. Yet that should not, because of the divergent and because you disagree with the position taken by your colleague, that should affect the manner in which you relate. One should be open to persuasion. The manner in which you look at a matter now may change, and you must have a listening ear. You must have an open mind. Where you eventually disagree with a position and you hold that you must express yourself, then you do so. You must do so respectfully. Your decision should not be a critique of your colleague's decision. You must be measured in your language. You must be respectful. And in fact, where you have to render a separate decision, you might have to explain yourself where you are departing from members of your court. The question as to whether there is a difficult question should be one that the judges sitting in that bench should take as a collective challenge, which they must, in a collaborative manner, deal with. And that calls for tolerance, and it calls for flexibility. Yet, at the end of it, if you must disagree, then you must do so respectfully and in a manner that endears to the principle of collegiality.
Thank you. One final question. In the Supreme Court, we have suffered from the perennial problem of quorum challenges. because the quorum of the court is 5, the number of the judges is 7. What advice, how would we resolve this problem that has been with us from the beginning of from the start of the court?
The question of quorum and...
Yeah, the challenges of quorum.
Yes. The number of judges that make up the Supreme Court is static, and it is within the Constitution. The quorum is 5. There will be times when a judge appears to be conflicted in a matter and unwilling to, or would otherwise be reluctant to hear and determine a matter. Yet, cognizant that of the small number of judges, questions of recusal of judges, questions of whether on application or that judges would otherwise make on their own motion requires to be done with a lot of caution. I am aware that the court has in its jurisprudence discussed this matter and have come out with the principle of the duty of a judge to sit. I think this was in the case, one of the Rai cases, the duty of a judge to sit. So, aware that of the few numbers, the court in addressing the questions of recusal must not approach it like any other courts would. And I think this jurisprudence that has been churned out sufficiently deals with it.
Thank you very much, Judge CJ, and I am done. Thank you.
Thank you. Thank you very much. We now move on to Commissioner Rwande.
Thank you, Chair. Good morning once again, Judge.
Good afternoon.
It is now afternoon,
Yes.
Sorry. Good afternoon. We finally get to move to the less technical and a lot easier segment of your interview. Yes, I have a performance report here from DISPOP. And I hasten to add that I'm having a bit of challenges, and I'm sure you're familiar with the challenges we may be facing, especially evaluating the performance of a collegiate bench. But I'll just give a summary of, because it's quite lengthy, and in the interest of time, I don't want to tire you with the many details. I'll just give a summary of what they have mined out of the work that you have done, and explain the approach I've taken in sort of analyzing it, and then you can tell me what you think about it and also the challenges that you see. So essentially what has been done here is that the work you have done, the benches that you have sat in various courts, the output in terms of merit resolutions has been compared to the output of the entire court. So they've taken into account the number of benches you've sat in over a period of 3 years, the merit resolutions vis-a-vis compared to the merit resolutions of those courts where you sat. So in total, I see you have sat in 14 benches. Yes, that's what I have, 14 benches. And out of the 14 benches, the merit resolutions, it's only in 3 benches. No, let me say 3 occasions, not 3 benches, but 3 occasions when the output compared to the total output of the particular court is higher than 30%. I don't know if you understand. That is now my own analysis. Mm-hmm. Yes, it's higher than 30%. So that 3 out of 14 times, your contribution to the total output of the station has been over 30%. The rest have been below. Now, I've already expressed the challenges that are there in evaluating the performance. The one that is so obvious, the performance of an individual judge, quite obvious. But then now as a bench, maybe you can share with us if, because you are the wearer of the shoe and you understand the dynamics, whether that is a safe approach And if you want to comment on the report I have just shared, you can also do that.
Okay, thank you. That report was shared with us a few days ago. I looked at it. I was surprised by the story it attempted to tell. Now, I would invite you, Commissioner, to look at by output when sitting in Kisumu. And I do so because of something I want to explain. When I was posted to Kisumu, we were 3 judges at any one time. And so we sat together as 3 judges all the time. It is then easy to judge the performance of that bench because it is constantly and ever manned by the 3 judges sitting together, other than on occasion when one is on leave or for any other reason away. Now, it will shock you that I have sat on 14 benches. I mean, this is when I moved to Nairobi, where we don't have fixed benches. Secondly, where I have had to be on relieving duties, either in Mombasa, Malindi, or elsewhere. So the statistics that you see are not unique to me as a judge, would not be unique to me, but would be reflective of the somewhat distorted picture that it gives when a judge finds himself sitting today with Judge A, then tomorrow with B, where the benches are not constant. What, in my respectful opinion, is that there might have to be remodeling of the manner in which the outputs in where judges don't sit constantly as fixed benches will need to be fashioned.
What are the suggestions you'd make, for instance? In what way? Fashioned in what way?
I think there would have to be a discussion first with the members of the Court of Appeal whether the benches don't need to be fixed. But if, in the end, if that cannot, for some reason, be feasible, no suggestion comes to mind. No suggestion comes to mind because it is very difficult to judge the individual outcome of judges sitting in a multiple bench. But that might, I do not know whether that it will be open for that to happen by looking at the individual output and what that does to a collegiate court, the implications it has. It's not an easy conversation to have, and I think it will require the output of the entire court and other stakeholders.
I appreciate that, and that's why I gave the disclaimer earlier that when it comes to the individual performance, that is not an area so far we can venture, and that's why the performance we are looking at is the performance of benches. You mentioned the Kisumu, the period you served in Kisumu. I have the statistics of Kisumu as well. You were 3 judges permanently, or did you have occasion to have different benches where you did not sit in?
Occasion.
There were some benches that
yes,
you did not sit
when one member would be on leave.
Yes.
But a substantial time sitting together, the 3 of us. Yes.
Okay, that is what I was explaining earlier when I said the output of the benches when you specifically sat was now being compared to the output of the court itself, including the occasions when you did not sit. But as you say, it's a bit difficult, and I think that's the other bit of the conversation we can have on another date, but that is what I have, and I appreciate the challenges. So the other question I wanted to ask Judge concerns performance in general. The carrot and stick approach is very common in most jurisdictions. I was just reading somewhere about a very interesting scenario in the Spanish judiciary. Apparently, in the Spanish judiciary, when it comes to performance, their carrot and stick approach is such that it actually affects your salary. So that you have a bit of your pay, your remuneration, as fixed, and then there's a bit that is pegged on your performance. You sort of earn a bonus. So that if you meet 100% of your target, then you get a bonus of 3% of your pay. If you exceed by about 20%, you get 5%. And of course, if you go below 80% of the target, you suffer until recently, you suffer a 5% cut. That is in the Spanish judiciary. Also in the US, there's a sanction in the fact that your performance results for all judges are made public. And you know, in some courts, they get elected to those positions so that it is possible that once your performance has been displayed out there, you may not get re-elected back to the court. Now, looking at our scenario back here at home, would you say that our approach is a carrot and stick affair, given our performance appraisal system?
So, thank you. First, let me start by saying that before the performance, the PMMU was rolled out, there was an engagement of stakeholders, one of who were members of the judiciary and judiciary staff. In the report that was produced by Justice Musinga, the question of reward took some prominence. I think the majority view was that those who did well needed to be rewarded. I think less pronounced in that debate is whether those who did not do well needed to be censured. Again, less pronounced was what is the manner, what is the carrot? Is it monetary? Is it recognition? Is it acknowledgement? I think that in the end, the manner in which we have used the carrot is one that has been agreed through engagement by those it affects. The manner of acknowledging, which the Chief Justice does often, outstanding members of staff, judges who have been exemplary, is, as I see it, effective way of rewarding excellence and good performance. Respecting the question of the stick, the manner in which we do it, it needs to be sensitive. It must not be in a way that in fact kills the spirit of those who are underperforming. It must be one that balances understands why someone is underperforming, one that encourages and sets out measures for improvement, yet one that the underperformer must be let to know that he's not pulling his or her weight in service delivery or in carrying out their functions. So generally, yes, I would agree. I think it is effective enough. There might be times when we will change that. I am aware that, for instance, because I have Gen Zs in my house, they might view these very differently. They are very open about certain things. They will tell you when you're wrong, when you're right. It might reach a point where they will say, if you're not performing, you take a pay cut. If you're performing, you are awarded or compensated in monetary. I am sure that a day will come when that conversation will be on the table.
Yeah, now that you bring out that angle, and taking your answer in totality, essentially, you agree that our approach to performance appraisal is the carrot and stick affair. Out of the proposals you've made, or even the observations you've made, it's not really worked in terms of motivating performance. The stick aspect, that is, has not really worked in terms of motivating performance. You have scenarios where someone feels nimefika. So what else is there to work hard for? So they don't work hard. As an institution, there is every effort to facilitate everyone. The remuneration is not so bad, maybe not ideal, but not so bad. But still we have those scenarios of people who simply will not pull their weight no matter what. So around here we've had conversations around Article 168, Sub-Article 1D, the question of incompetence. The argument being failure to meet performance targets is incompetence. I don't know what your view will be about that. It's rather controversial, but I would want to hear what you think about it.
168.
168, 1D, basically incompetence as a ground for removal.
Okay. Yes. You know, Commissioner, I thought you were talking generally about judicial officers and judiciary staff, not just judges. So in respect to judges, I think the Constitution speaks clearly and loudly. I'm trying to recall whether that section has been used to set up a tribunal which investigates a judge. It doesn't. I'm not too sure it has.
Not strictly speaking, no.
Yes.
It has not, but it's a thought.
It's a thought.
I just wanted your take on it.
Yes. Given the criticism that the judiciary has to deal with daily, online, when you meet people, when you have interactions about certain whether we are suffering a question of competence and capacity, I think I'd leave it to the Commission to have that debate. The Chief Justice, as the head of the judiciary and also as the chairperson of this commission, they might be need to see whether in future it can be invoked. But the caution perhaps is that how does one measure incompetence? Where it is obvious and where it is clear, then I do not see why it cannot be a measure or a reason for removal of a judge. Otherwise, to say it isn't is to say that that provision of the Constitution has been put there and it is idle and it should never have been. But the challenge is to the Commission. The challenge is to the Commission. We will give our views when invited.
Okay, thank
All
you.
right,
thank you, Judge, and I wish you well.
Thank you.
Lady.
Thank you. Commissioner Zirani?
Thank you, Honorable CJ. Good afternoon once again, Judge.
Good afternoon.
It's okay, you can go ahead and take your water.
Yes, thank you.
You're good to go?
Yes, I am.
Okay. I will start you off with a quote, and then you'll tell us your understanding of the quote and give us your views on the same now that you want to ascend to the Supreme Court. It's a quote by a U.S. Supreme Court judge, and he says, "The Supreme Court is not final because it's infallible, but it is infallible only because it is final. The Supreme Court is not final because it is infallible, but it is infallible only because it is final. What do you understand by this quote? And maybe you give us your views on the same.
Now, the Supreme Court is the apex court in the country. It makes difficult decisions with far-reaching consequences. It speaks with authority. It sets precedents. Now, notwithstanding that it is a final court, there will be occasion when a further reflection of a decision made today reveals a rethink. When that occasion arises, and there might be many or few, the Supreme Court must reflect as to whether a mere change of mind should lead to departing from a past decision it has made. This is because, as the apex court, cognizance of its importance in that ladder, it is expected that the Supreme Court will have given deep thought to the decisions it makes, and there shouldn't be too much occasion for revisiting a decision made. This gives stability to the law. It allows members of the public, there is then predictability as to organize themselves, knowing that this is the position of the law in certain aspects. So, yes, the Supreme Court is not infallible. And this is not just in respect to the Supreme Court of Kenya. In America, for instance, on the question of the abortion question, Roe versus Wade, there had been immediate debate as to whether the judges themselves were right or wrong in that matter. And the debate can be as soon as the next day or the week after. But I think the position that the Supreme Court took was that there is value in stability. Let a matter settle. Let there be widespread debate before you change your mind on a matter. I say this, nevertheless, aware that if there is a matter that is glaringly a wrong position, then the Supreme Court should be able to presented with a situation where it requires to rethink its position, then it should do so. But it should not be within reviewing the matter itself. Now, when the second part was if you could just say that quote again. So
the second part was your views, and I think you've already given that. Yes. What do you think of the quote? The
second aspect of the quote.
The quote says, I read the quote again?
Yes, please.
Okay. The Supreme Court is not final because it is infallible, but it is infallible only because it is final.
It is infallible only because it is final. I think that when you're placed in the position where you have the last word, and where your word is the law in certain respects, it puts you as well in a position of vulnerability, because when you make a decision, that eventually revisited many years later is one that you should not have made, then you did not have the opportunity for an immediate second look, but you've had yourself to deal with it later. I've tried to thread the needle there. I'm not sure I've done it. Yeah.
All right. My second question, please describe a situation in your career where you had to take a position in a judgment, ruling, or public stance that conflicted with your personal beliefs, your political views, your personal and professional relationships, or your social environment, and tell us how you handled the situation and perhaps any lessons you learned from the same.
You'll allow me not to give specifics, because I don't to reveal who I have disappointed and who I have not,
Okay.
or to really, if you'd allow me to
pass that on?
Yes. No, but I want to say how I could possibly, I have dealt with it.
Okay.
I've had absolutely no difficulty. And because in respect to the opinion of others, I have tried to be clear in my views as to why I arrive at a certain decision. I shun from explaining myself, even when invited by those who thought that I should have gone a different way in a matter. I invite people to look at my judgment and to interrogate it. It's slightly different where you have an internal conflict where your decision goes against what you strongly feel about. I haven't had many of those, and I take it to be different from the situation asked by Commissioner Lady Justice Njoki Ndung'u in respect to where the outcome of the decision or the reading of the law and facts is not in consonance with your sense of justice.
Okay. Finally, for me, it will be a follow-up from Justice Njoki's question on where you do not agree with members of your bench when making a decision. Should a Supreme Court judge write dissenting opinions, or does dissent undermine institutional collegiality and the court's legitimacy? Maybe you'd also tell us what the implications of writing these dissents would be.
Thank you. A judge ought to write a dissent where they feel strongly that it is required. It must not be on minor, what one would say, disagreements on insubstantial issues. The value of a dissent is that it invites a more holistic debate on a matter. It brings out different perspectives regarding an issue, and no doubt a good thing for the growth of jurisprudence. Is dissent then one that is in conflict with collegiality? Not at all. In fact, if you have a strong view which you refuse to express in an opinion when you ought to, then it does not, you're not being open about your position. Dissents, when they are properly worded and where indeed there is real occasion for or need for dissent, can enhance collegiality. As judges, we should be able to express the differences of opinion freely and openly, candidly, and knowing that we are all members of the court accountable jointly to the people of Kenya. And if a dissent will enrich jurisprudence, then I'll take it that in fact you are promoting collegiality. You are enabling your brothers and sisters sitting in the same bench to be able to be more accountable to the people of Kenya.
Okay. Would there be concerns if the dissents were coming from one judge and if they were frequent?
It might be a reflection of judicial philosophy. In fact, if there is a judge who holds a certain judicial philosophy and is feels very strongly about that philosophy, dissenting in circumstances which reflects that philosophy is a good thing. It is an attribute to the judge in respect to the consistency in which they approach matters.
Okay. Thank you, Judge, and I wish you well.
Thank you.
Thank you, Commissioner Kiswato.
Thank you, Honorable Chair, and welcome again, Judge.
Thank you.
I want to take you to a softer area now that you have sat on that seat for over 3 hours.
Oh, really? Oh my.
But we are not very far from concluding now. Could you tell us what ethical challenges might a Supreme Court judge face? And you could also share with us your proposals on how to overcome such challenges in the event that you are successful in this bid.
Ethical challenges. Over time, the judges in the past, those who've gone before us, have developed certain principles that try to put us as judges in the straight and narrow. Starting from the Bangalore principles, and then for us, the code of conduct. When you're faced with certain ethical challenges, I think your grey book ought to be the code of conduct. That should be the starting point to see how to address those questions. That would be my short answer.
Now, there was a question you were asked earlier on by Commissioner Olwande on performance, and I would want to hear how you will deal with a situation where you are part of a bench where one judge consistently delays judgments, of course, causing a delay in delivering of justice. What steps would you take?
Thank you. There are two ways of addressing this, and it might depend on the position you take in that bench. If you are the presiding judge in the bench, one of your responsibilities is to whip up members of your bench in terms of performance of their work. If I was the presiding judge, it might be easier for me to remind my colleagues who are falling back in a respectful manner on how to deal with delayed judgments. It seems, nevertheless, that a better way might be to set out together as colleagues a framework for checking on each other as to when one falls behind. You could agree that a manner of reminding one another as to a decision that has delayed, so that the reminder is not seen as a censure, it's not seen as disrespectful, but the system that you have prescribed yourself to, itself reminding you that you are underperforming. It may seem to be a difficult question, but if you do it in a respectful way and trying also to understand occasion when there will be real difficulty or real reasons why a decision has been delayed, if you try and interrogate it, then you might find that you are able to deal with it. I know, for instance, that there are times when a judge, for some reason, has been unable to churn out a decision either out of illness or out of the complete difficulty of a matter, and has discussed it openly with members of the bench, and one other judge takes up the task. So there are many ways of dealing with it. Yeah, thank you.
Okay. Now, Article 232 of the Constitution calls for both equity and meritocracy. How would you resolve a situation where affirmative action objectives appear to conflict with this, with a strict merit base?
The provision of affirmative action in the Constitution is a recognition of historical reality. And so the framers of the Constitution were deliberate about addressing certain inequalities, whether they be gender, regional, ethnicity, and so forth. And the provision is there deliberately in the law, in the Constitution, to deal with that. The question would be whether in implementing affirmative action, whether it should always trample on merit. It's a balance that one has to walk, because the Constitution does not have conflicting provisions. They must be implemented in a manner that is harmonious, that one supports the other. If I was on the implementing body, I would have to try and devise a manner in which to strike a balance. For instance, in respect to, and this is one way, in respect to whether someone falls short of merit, yet there is a question of affirmative action, I think it would be wrong to only apply the question of affirmative action when it is glaring and it is not explainable that a person who falls so much short of merit should be given a certain position. It's a difficult question, but one must bear those parameters in mind.
Okay.
Thank you.
Thank you. I wish you well, Judge.
Thank you, Vice Chair.
So it's afternoon now?
Yes.
Are you tired?
No.
Oh, yes. I can do a little bit more. So what is the role of President at the Supreme Court? And what factors lead to possible revision of the same?
The role of President. Now, the manner in which the Constitution sets out the role and mandate of the Supreme Court, it declares very clearly that the Supreme Court, the decisions of the Supreme Court are binding to all other courts. And once the Supreme Court has made a decision in respect to a matter, then the other courts are obliged to follow the principles in that decision. The value of a precedent, I may have mentioned this earlier, is that it brings predictability on the law, so that one is able to understand their obligations, their rights, and can be able to predict almost accurately that a question I put before the courts could either go this way or the other. I don't know that I have addressed your the second aspect.
Yes, or we can leave it.
Okay. Sorry, if I don't want to leave anything unturned. Yeah, the second aspect.
I was just wondering for how long is it valid?
How long?
Is it eternal, or what factors could lead into such revision?
Yes. If you'd allow me just to repeat myself, I think the Supreme Court should be slow in deviating from its past decisions unless there is extremely good reason. And that calls for a heavy responsibility of the judges of the Supreme Court, so that they are careful that the decisions they make can stand scrutiny and can stand the test of time.
Okay. All right, then what does judicial independence mean to you?
Judicial independence. Judicial independence. There might be two limbs to this. Indeed, there are two limbs to this. The question of institutional independence, which Commissioner Deputy Chair, this commission is very important in terms of safeguarding. Institutional independence would mean that the recruitment of judges and the work of the JSC is truly independent, the funding of the judiciary, and so forth. Those that speak to the institutional independence. Then there is the individual independence of judges, one that is safeguarded by our tenure of office, the manner in which we are recruited, and our solemn oath of office not to be influenced in any manner by external factors in the manner in which we discharge our duties.
Okay, thank you. Thank you.
Thank you very much.
Yeah.
Thank you very much, Judge and Commissioners. I think this now brings us to the end of a very long interaction and deliberations with you this morning. But before we finish, we always give a candidate also an opportunity to engage us. So the floor is yours.
Thank you. Can I just, if you'd allow me, just to take this opportunity to thank you once more for this chance that the Commission has given me. I am also aware that there'll be people who will be following on YouTube. And just allow me, my lady, the Chief Justice, to just thank, in a special way, members of my family and all the colleagues, particularly the Court of Appeal, who see me as the quiet team member, lifting his weight quietly in a corner and needed to be urged on to apply for this esteemed position. Let me thank them very much. Sorry. A little emotional there.
Thank you very much, Judge. On behalf of the commissioners, we wish you well. We wish you success in all your endeavors. You are one of us, whichever the case. Therefore, we like to really encourage our candidates to keep up the hope. I think now we are finished. You are discharged.